Bienvenue à tout le monde. Welcome, everyone. It's great to have everyone with us here today virtually. Je voudrais reconnaître que nous nous trouvons sur le territoire algonquin non cédé. I want to recognize that we are here virtually, and many of us physically, on unceded Algonquin territory. We are incredibly privileged and excited to welcome our guest, Dahlia Lithwick, here today. It is very much a homecoming for Ms. Lithwick, as she is originally from Ottawa. She grew up in Ottawa. She is a graduate of what is now the Ottawa Jewish Community School and Nepean High School, which I understand, if I understand correctly, from my son who's also a graduate, we are supposed to love purple, live gold. Does that ring a bell? And after that, she left Ottawa and had got a BA in English at Yale University and her JD from Stanford Law School. She is one of the leading writers and commentators about SCOTUS, about the Supreme Court of the United States. From 2008 to 2011, she was Newsweek's legal columnist. She has written for many years for Slate, and she has a podcast about law and the US Supreme Court. She has appeared on CNN, ABC, The Colbert Report, and The Daily Show. She is now writing a book called Lady Justice about women and gender and the US Supreme Court, and we're very excited about that. I have to tell you, I've been fortunate to have met Dahlia probably about 10 years ago. And I've been a big fan of her writing, her analysis on the US Supreme Court. We were unfortunate that in Canada, we don't have as many people like her covering the Supreme Court of Canada. Her writing and her commentary is an incredible model for journalists, for students, for academics. The late Justice Ruth Bader Ginsburg has called her spicy, and Justice Samuel Alito has called her some hack. Those are both different perspectives. She brings incredible expertise and insight, and we are just so incredibly privileged to have her with us today in conversation with the co-director of the Public Law Center, Professor Vanessa MacDonnell.
Thank you, Adam, and welcome, Dahlia. As Adam said, it's a real treat for us to be able to speak to you today and to get a sense of both your career trajectory, you know, how you started in Ottawa and ended up in Washington covering the Supreme Court, but also increasingly covering US politics, covering the Trump presidency. And there's just no question that there's been a lot to report on in the last couple of years. So I was hoping you might be able to start off by telling us a little bit about your professional trajectory.
I will. And Vanessa, thank you. And small person, hi. And Adam, thank you so much to all of you for inviting me. It really is like coming home to Ottawa, even if I'm not with you. The trajectory was actually just a function of going to college in the US. And once I went to college in the US, it sort of felt slightly inevitable to go to law school there. Between Yale and Stanford, I worked on a book. I had been at Paul Newman's camp for terminally ill children in Connecticut for a bunch of summers. And so I got really obsessed as I was working on the book with health law policy and why it was that these kids that I was working with, all of the principal struggles they had in their lives were not their health struggles. That was bad enough, but the sort of thorny how to get through the endless no's of the healthcare system. So I became really obsessed with doing health policy. Stanford was the obvious place to go there. So in a weird way, I kept kind of bricking myself out of coming home. And then the short answer to how I got from law school to being a journalist, quite honestly, is that I was just a really crap lawyer. I worked in Reno, Nevada. I clerked for a judge on the Ninth Circuit Court of Appeals, which is the big appellate court on the West Coast of the United States. And then I did 2 just hellish years as a family lawyer, fighting over the Tupperware. And I was like sobbing at, trials, and it was clearly not working out. And so when I left Reno, which is like a book in and of itself, I ended up in Washington, D.C. at, quite honestly, precisely the moment that Slate magazine, which was pretty much brand new, was looking for somebody to cover the Microsoft trial. And I didn't understand antitrust. I hadn't even taken antitrust. Note to students, take antitrust. I didn't understand what an operating system was. I couldn't figure out why this huge suit was happening, but I covered it anyway. Mostly just by telling jokes. And then I was just lucky enough. In fact, I came home to Ottawa after the trial ended and stayed in my brother's basement and was determined to nanny for his kids forever. And my bosses at Slate called and said, "Where did you go?" And I said, "The trial was over," but still didn't understand what had happened. And they said, "Come back and cover the court." So that was in 1999, and that's been my first job.
Well, that's very interesting. Yeah, it's and from there was really born a fairly remarkable career. So can you give us some insight into what you've learned about the court and its workings as someone who's had really a front row seat on the court for 2 decades? I think even lawyers who appear as a matter of routine in the court or who follow the court closely, very few people cover the court or know the court the way you do. So do you have some, general observations about the court that come from having been such a close watcher?
It's a great question, Vanessa. And I think the short answer is that the US Supreme Court is complicated. Adam, I think, flicked at this in his introduction, but it's very much, on one level, there's only a handful of reporters credentialed to cover it. And I was the first online reporter who got a press pass. And then once I was in the press office shortly after that and overheard that my nickname there was the barbarian at the gate. Like, they really didn't want to let anybody else from an online publication get credentialed. But I think that there's a weird way in which, even though there's, 30 or 40 kind of permanent press reporters, and then obviously like the big cases like Bush versus Gore, or the big guns case Heller, or the big abortion case June Medical, then you get huge numbers of people in the court. But for the most part, it's a pretty small press corps, and it's very, very dedicated. Like, it really is the dorkiest, wonkiest. This is not a beat where you get scoops. You never get scoops. You can root through the dumpsters out back all day. You'll never get anything. It's not a beat, even with the exception of some reporters. Nina Totenberg covers the court for NPR, gets access. Adam Liptak covers it for the New York Times, gets access. Joan Biskupik, who covers it for CNN now, has actually done biographies of several of the justices. But most of us spend our lives hoping to get a one-on-one interview, never getting it. And so I think that the long version of the short answer is it's a very reverent press corps. It's not there to stir up trouble, not there to dig dirt. In some sense, and this is, I think, unique in some ways to the United States, we think of ourselves as kind of junior con law professors. And what we spend our time doing is explaining the law. It's not a gossipy beat. It's not a beat where, I used to joke that you'd come into the press room after any argument session and, Clarence Thomas would have been like asleep with his head back, not talking for a 2-hour session. And I would be like, "Did anybody see what happened, to Clarence Thomas today?" And everyone would say like, "Did you see what happened to the rule against perpetuities today?" Like, it's really, really dorky. And the law is alive in our eyes, and the justices are kind of not dead, but not super interesting. So it's a very weird beat, and it's a weird beat. And I'll finish here because it's a long answer that's growing longer, but it's a super weird beat in that despite all that, there's an immense amount of hagiography, and Americans are obsessed, right? Like with the RBG, you know, I have the candle here, I've got the votive candle, but like, you know, the handbags and the coffee mugs and the throw pillows and the t-shirts. And so there's an immense amount of kind of public love for the justices as personalities. And it's totally team-based, like your team Scalia or team Ginsburg, your team Alito or team Sotomayor. But at the same time, the press corps isn't super interested in that. The press corps is very, very academic. I think that's a good thing, but it means there's a huge disjunction around the public conversation about the court and the one that the press corps is doing day to day. I don't know if that makes sense, but I think that's really striking to me.
Okay, so maybe you can tell me a little bit more about that. I think that's really interesting. So, you know, what does it look like then to cover the court well? I guess it sounds like that journalists who are covering the court regularly outside of, as you say, like, you know, the big cases, that they're really trying to perform this educative function in a way, or make sure, try to demystify the court in a sense. So, you know, what in your view does good reporting on the court look like?
Yeah, I love
some of those things at the edges, the scuttlebutt, you know, that like that you mentioned.
Yeah, I love the question, because I think as I have thought, you know, after 20 years of doing this beat, what I would do different. I think one of the things I would say is that we cover cases. So, you know, in September, right, the term opens the first Monday in October. In the last 2 weeks of September, we all do our kind of curtain raisers where we say, these are the 6 cases to watch. And it's almost collusive. I mean, it's really almost as if we all agree that these are going to be the big ticket cases. And that's a mistake, because A, we're often wrong. B, the court adds cases to the docket that are much bigger. And C, it really deflects attention away from incredibly consequential cases. So I think we tend to, in an effort to humanize, you know, and I should note here, because it's quite shocking, you know, the United States Supreme Court only hears like 70 some cases a year. I mean, they get thousands and thousands and thousands of petitions for certiorari, and they only hear a tiny handful of them. And so I think that we get hyper focused on the gun case and the abortion case and, you know, the LGBTQ rights case, which is all correct. But then we end up, I think, disserving our readers by like flying out to Arkansas and interviewing, you know, one of the parties and trying to tell a story. And in trying to humanize it, I think we sometimes forget to cover the law. And so my sort of fantasy, if I could go back and rejigger court coverage, would be, instead of covering the case qua case that year, I would be really interested in a sort of longitudinal, the ebbs and flows of the law itself over the years. And so, for instance, like there was a really big case out of Seattle that had to do with, you know, whether schools could stop busing people to effectuate some of the racial desegregation stuff that was demanded in Brown v. Board. It was a case that we covered and then we moved on. And I always find myself wondering, like, how did that change things? Right. How did the busing change? What did parents decide to do? And I feel like we don't do that. We do it in law school.
Right.
We cover doctrine. But I think we're very, very personality driven and sort of dispute driven in coverage of the court.
Well, that's actually something that we sometimes talk about in our constitutional law classes. I mean, I think law professors can in many ways be accused of the same thing, right? Like we don't always emphasize that the case is actually a moment in time. It's not the beginning of the story and it's not the end of the story. And yeah, I think it helps to understand the court if you understand that dispute, as you say, is just a moment in time. It helps us understand the kind of broader context that the court is part of.
I mean, it makes me think that in some sense you always have two audiences, right? I mean, you as a common law professor are trying to teach doctrine to students. And so it almost has to be disaggregated from that one story in that one case. Part of the problem in court coverage is that we have two audiences. We have an audience of lawyers who are desperately interested and steeped in the doctrine. And then we have lay readers who really, I think, feel about court reporting the way they feel about science reporting, right? Like, I don't know what this is. And so you have to really draw them in, and you have to, in some sense, create urgency that, you know, even though this case seems it's just about, you know, this one dispute in Pennsylvania about, you know, who is licensed to make sure that children are adopted. That's Fulton, one of the cases that's pending right now, but it affects everyone and everything, and it's going to change everything. And I think that's the dance we're always doing, is both telling the story, making these parties really sympathetic, trying to explain the stakes, but also, as you say, sort of plugging it into this slipstream of what's come before and what's going to come after. And that's, I find that it's just challenging. And I would note, and here I'm going to just sound like a grumpy old grandpa shakes fist at clouds, but like, this has really changed with the advent of, you know, the internet, because we used to be able to, you know, you'd cover the case, you'd cover the decision. On Sunday, you'd write like 3,000 words saying this is what it all meant, and, you know, sort of chew it over. More and more now, if you haven't filed your story before, you know, the argument is finished, if you haven't tweeted out what happened in argument, you know, I can't tell you how many times I've had colleagues in the press corps, grumpy old grandpas like myself, who say, you know, I went back to my paper and pitched 3,000 words for the weekend and was told it's too late, nobody cares. And so I think that this super compressed press cycle and the sort of attention deficit that we're living in this press moment really confounds the problem of making the court and doctrine understandable.
Yeah, well, I think that's right. There's probably challenges inherent to covering these topics as a journalist in the run of a single article to begin with, and then you add the kind of tech component to it, and yeah, there are real challenges in terms of telling that deeper story or longitudinally kind of tracking the way a case is unfolding. I'm just going to say I didn't do this at the beginning, but I'd like to welcome members of the audience. If you want to put questions in the Q&A, I'm going to, you know, I have a number of questions that I'd like to ask, but we will take some questions from the audience. And if you're a student in particular, identify yourself as such, because we do really want to make sure that students have an opportunity to ask questions today. So please feel free to drop your questions into the Q&A really at any point during the discussion. I want to pick up on something interesting that you said, Dahlia, about covering cases more than sort of covering the court or covering individual judges. Because one of the things that I've started doing in recent years in some of my classes is actually assigning judicial biographies to students. I did it for the first time in the context of a seminar on the Supreme Court, but then decided I was going to just assign these a little bit from 2 biographies just in the first year constitutional law class. Because my sense is, you know, when you read these biographies and you do the deep dive, you get to know who these judges were. You start to see the interpersonal dynamics that exist on a multi-member court and the way that actually influences decision making. And to me, you really learn a lot about the institution, and in particular, the kind of human, like the truly human aspect of even a top court like the Canadian Supreme Court or the US Supreme Court. You have snagged some amazing one-on-one interviews with justices of the Supreme Court. And can you tell us a little bit about what you've taken away about the court and the institution and the people from being able to sit down with these judges and talk one-on-one?
So I think I want to start one place back from where you just started. which is
Sure.
that, and I think this is something that is quite unique to the US Supreme Court for a lot of reasons that have to do with, like, you can go back to the Federalist Papers and the sort of decision to make the court simultaneously totally powerless structurally and completely omnipotent, right? And so, if you read Federalist Papers, they're saying, oh, they have neither the power of the purse nor the sword, right? If the US Supreme Court doesn't behave, technically Congress could vote tomorrow to like shut down the plumbing in the bathrooms and turn off all the lights. The court doesn't have an army to enforce its directives. It doesn't have any inherent authority. And so the court has always simultaneously been almost too powerful and not powerful enough. And the way over time, over 2 centuries, they have thought about, how do we make peace with that idea? How do we have Americans not like standing with flaming torches out front on Maryland Avenue every time they dislike a decision? And Justice Breyer's written 2 very turgid books about this, but it worries them. It worries them across ideology. How do we maintain legitimacy when we don't in fact have any real power? And the way they chose to do that is quite funny, which is to present themselves as these kind of oracular brains in vats. And so, for instance, for years, for centuries, if you looked up a transcript of an oral argument at the US Supreme Court, it didn't say, Potter Stewart asks this question, William H. Rehnquist asks, it just said the court.
Interesting.
And you couldn't quite literally reconstruct which justice was asking questions at oral argument unless you were there or knew somebody who watched the arguments. And they really felt very strongly that their personalities had nothing to do with it, and that their names even had nothing to do with it. And it took a really, really long time to even get, in my career, to even get the court to release things like when they give a summary of a decision, when they announce from the bench what the opinion is and they give a summary, they wouldn't release that. And you'd be like, dude, if that's the summary of the case, we kind of need to know it. And they're like, no, just read the opinion. And so they were very, very protective of this idea that justices come and go, but they're all brains in a vat. And it doesn't matter who's who and what's what. And if you would like call the court and say, Sandra Day O'Connor gave this really weird speech in France. Can I get a text of that speech? Literally, they were like, it doesn't matter. You can't see the speech. We're not giving you a copy of the text, and go away, because the only thing that matters is in the 4 corners of the opinion.
Right.
It's kind of psychotic, right? Because it's such a desperate attempt to sort of do the Wizard of Oz thing, like pay no attention to the person behind the curtain. And the thing that actually happened in not exactly in my lifetime, at the beginning of my lifetime, was this book, The Brethren, that comes out, which is this tell-all gossipy book by Woodward and Armstrong that really peels open the Burger Court and is like, everybody dished, all the justices were complaining about one another, and it was like a soap opera. And as a consequence of that, all the justices just clamped back, and they had no public interviews. They were, Justice Brennan stopped doing any public events. Some of them stopped going to speak at bar associate. They just were back to the brain and vat theory of the case, right? And that was the court that I started covering in the late 90s, where you could almost never get an interview. The justices wouldn't go on television. They wouldn't go on radio. And then, arrestingly, it was Justice, Antonin Scalia, who's probably the largest larger-than-life character I've ever covered, who all of a sudden sort of blurted out, look, if we're going to be in the public conversation, let's just, his words were hilariously, come out of the closet and be in the conversation. And he was the one who really started saying, I want to be in public discourse. I don't want to say, it's confined to the 4 corners of the opinion. And then we just had a real burst of, justices writing sort of autobiographies, writing books. Clarence Thomas wrote an amazing memoir, did a whole raft of interviews. So I got to actually watch that arc kind of collapse on itself, where the justices went from being extremely secretive, extremely wedded to the idea that it doesn't matter which one of us said it because we're all the same, to suddenly, like Sonia Sotomayor was throwing out pitches at ball games, you know, and Elena Kagan was like getting caught, you know, eating pizza everywhere. And so it really changed in my lifetime. And that's, I mean, the reason I'm sort of saying it in such a long-winded way is because it really, to me, gets at this central tension about the US Supreme Court, which is that it wants to hold itself out as oracular and perfect and nonpartisan. And, you know, even this week, Justice Stephen Breyer, like, was at pains to say, we're not politicians. Politics has nothing to do with it. I don't know what you're talking about. We're just, you know, oracles. And at the same time, like, they're selling books and they're giving interviews and they're going on radio shows. And so it's that seam of being individuals and personalities who write biographies, who have relationships, who really have a kind of behind the scene horse trading, and that clearly is going on. That's part of the story. The other part of the story is the one they want the public to believe, which is, you know, we are all just doing justice, balls and strikes. There's no politics, there's no ideology. And I have felt in my career just a kind of pull, toggling between those poles. Because there's a really great book that I would commend, especially to the students there, if you're interested in this, by a guy whose name is Keith Bybee at Syracuse University. And the title of it is something like All Justices Are Political Except for When They Aren't, which is really, I feel like it could be like tattooed on my back, because it's you have to hold those two ideas in your head at the same time, that they're completely people, ideologues, they're political animals who have swum in political water in order to get these jobs, and also that they're doing something different, that in their view, what they're doing is not pure politics. And so, you know, I've been very lucky. I got to interview Ruth Bader Ginsburg just a few weeks before the court shut down completely for COVID. I think I got one of the last big public interviews with her. I got to interview Justice Breyer this winter. I think I've met almost all of the justices. I did a very fun public event at my son's school with Justice Kagan. And what I would say is, across the board, their overwhelming message they want to get out is that they are not politicians. They are constantly doubling down on this. What we do is fundamentally, you know, communing with the framers and like the Ouija board, you know, view of the world. And it has nothing to do with our personalities or our politics. But oh, by the way, like whispers Ruth Bader Ginsburg, like her friendship with Justice Scalia is the single most important friendship and a model for bipartisan. Like, so they want it both ways. And it's always, particularly for law students, very, very frustrating to try to live in the sort of interstices of those two stories.
That's right. Well, and I think you're right that those two stories exist alongside one another, right? And the truth of any one of those stories probably depends a lot on the individual context. They're probably both true, to some extent, right? So maybe you can then talk to me a little bit more about, so we've talked a bit about the court and the court's imagination, the way that the US Supreme Court justices think about the court. And you mentioned a little bit about the view of the court in the public imagination in the US. Can you tell us a little bit about the role that the court occupies in the US public imagination? Because certainly in Canada, you know, our judges are not rock stars, right? They may be minor celebrities within the legal community, but there are no candles. There are no children's books. It's really, you know, and I think many of the judges like it that way, actually. And there are, you know, in Ottawa, you could walk down the street and see a Supreme Court justice in the street going unnoticed. Just culturally, I think we don't have that same affinity, or the court just doesn't have that real public facing, well, they have a public facing role, but there's no celebrity status. So can you just maybe talk to us a bit about the court? Because my sense is things are perhaps a little different in the US.
Yeah, it's quite different. I would say it changed. I think 70 years ago, you could walk down the streets in DC and walk, by a Supreme Court, Felix Frankfurter, and nobody would know. And it's not going to surprise you to hear that I think the advent of the week-long gavel to gavel confirmation hearing really played a part in that. I mean, there was never a camera at a US Supreme Court confirmation hearing until Sandra Day O'Connor came along. Why? Because the first woman, because Reagan had promised a woman, he delivered a woman, and everybody wanted to see. So in a lot of ways, she becomes this rock star celebrity justice, right? She gets stacks of mail every day. So that's a part of it, is that the confirmation process, which is so different from the Canadian process, really becomes almost like a reality TV show. It's like Survivor. Are they going to make it? And everybody watches and people care. And, there's 1,000 witnesses and everybody is checked into it. And I would just note, looping back to my last answer, that's a huge problem for a court that is trying to de-emphasize individual personalities, because don't forget, the US Supreme Court is not televised. So you only watch Survivor. You watch the reality show of their confirmation hearing. You may never see them again. And so they have made, I think, a really backward decision to keep the court off of television doing the sort of mind-numbingly boring maritime law stuff that they do, and instead have like the job interview with everybody screaming and senators posturing. And I think that that's really profoundly upended the story that the court wants to tell about itself as non-political, right? The only thing we're watching is the political
stuff.
And I will add, because it took me a long time, I think I've covered 7 confirmation hearings. It took me a long time to realize that most newspapers don't send their Supreme Court reporters to do Supreme Court confirmation hearings. They send their political reporters, because it's a purely political story. And so like, you'll be on speed dial with your Supreme Court person to say, I'm sorry, what's Griswold versus Connecticut? I don't know what's happening right now, but we're not covering it. Or we're covering it to do sort of sidebar stories on politics. On the law. So I just think the United States has taken, I think, a sort of sideways approach to this, which is, if you want the court to be sort of small in the public imagination, you can't do these blockbuster confirmation hearings where everybody picks a side and everybody watches just enough to think this is purely partisan. And I think the justices, I mean, we can talk about this, but it's really interesting. Sam Alito, for sure, Clarence Thomas, to a lesser degree, Brett Kavanaugh, were so bruised by their confirmation hearings, for obvious reasons in some cases, that they never get over it. And so, query whether that's smart in terms of doctrine, right? Like, you are now polarizing and politicizing something that we all know is just empty theater. So I think that Americans have almost the same problem that I described at the beginning, which is, in one sense, the court is too big. They care too much. There is so much mythology. There is so much of the t-shirting and the, when Justice Scalia really learned how to write a dissent that was eminently tweetable, it became a whole cottage industry. How do you write as a justice for Twitter? And they're mindful of that. And that's not good for the court. It's not good for understanding the law. And at the same time, I think Americans don't really understand how vulnerable the court is, how scared the justices are of being seen as partisan and political. So it's that same problem. I think that, there's a perception that they're larger than life, that they're oracles, that they're sacred. I often joke that for a ostensibly secular country, the American people are the most religious people, and the court is the temple. I mean, it is styled as a temple. It is, they walk around in those black robes. Looks like a sort of oracle at Delphi, deliberate construction. And then at the same time, the stories that Americans tell are so hot button, partisan, political, crazed, and that has obviously really ramped up with Kavanaugh and with Amy Coney Barrett, with RBG, with Sotomayor. So now I just think we're in this very weird posture where Americans know both too much and too little at the same time, and have very strong feelings about all of it.
This is great. So I think you're right. These are complicated stories, right? There's not really a simple narrative about the court as an institution or the individual judges. I was hoping that maybe we could talk a little bit about some of your more recent work, and in particular, your shift to covering US politics, and in particular, the erosion of democratic norms under the Trump administration. What was it like writing about, watching and writing about the Trump presidency, and in particular, shifting from the court to looking at other public institutions and the way that constitutional norms were being upheld or not in that context?
I joke that my life changed 1 week after inauguration, only because that was when the travel ban was signed, right? So this was the first iteration of the ban that would have precluded either immigrants or, permanent resident aliens from a whole bunch of majority Muslim countries from entering the US. And it changed in a couple of ways. One is, as you're saying, fundamentally, this is a legal question, right? And it is a question of executive power, and executive power to set immigration law, and, incredibly intractable questions about, the First Amendment religious clauses, and was this religious discrimination? So it's like, right, it's a whole con law class, like cascading down on your head. But also, like, it happened on a Friday night, and we worked all weekend, and we filed 7 stories, and it never stopped. Like, that was the beginning of what I now jokingly call sort of the law of Trump, which is, on any given day, whether it was, threatening to do away with, I don't know, whatever First Amendment law he didn't like that day, he'd just be like, oh, that's it. We're gonna change the law of defamation, and then you'd have to be like, okay, can the president, so there was never a day in the Trump era where there wasn't either a tweet or an executive order or some agency putting into effect some policy that had huge legal sort of valence around it. And so I think part of what was really interesting was, like, we never got weekends back. We never had nights. You would be, I cannot tell you how many nights I would be like in my pajamas and then get a call being like, okay, spackle on some makeup because you're going on Rachel Maddow in 10 minutes to talk about something. And it was a legal question, but it was also, like, often a legal question of first impression. Like, wait, can the president actually do this? And so it was hectic and hard. And I guess I would just say the through line for me that I can see in the rearview mirror, but couldn't see at the time, was the extent to which a lot of these questions were like, can the president do this? And then you would see that it actually transcended law. Like, of course, you can't just ignore a congressional subpoena in the middle of an impeachment. But when Don McGahn did, or John Bolton did, there were no consequences. And so I think in a very strange way, I came out of the 4 years sort of, this was the speech I used to call Welcome to My Breakdown, but it was like, you think that the law is self-reinforcing and self-effectuating because people have made a collective agreement to do that. And it was 4 years of, what would happen if, the president simply decided that he was going to do a thing, that we were going to start separating children, from their parents at the southern border, and, by the way, lie about it, and what was going to stop that? And so I think, in a weird way, that was the mind bender, was the, what do you do when the law has an outer limit and you're kind of crashing up against it every day, and people are saying to you, but he can't do that, right? And you'd be like, yeah, I don't know. That was the really twirly part for me, was that I think, being a creature who came through law school and clerked and thought about the law, I thought it was more stable and rigid than it actually was.
Yeah, I think there's been, I think an acknowledgement, certainly in the scholarship as well, that came out during the Trump period about, and I know, Jamal Green has done some great writing on this, about the extent to which so much of our democracy, our democratic culture is actually norm-based. Like, it's not the hard law, it's norm-based, and we've all sort of agreed to the ground rules. And when someone decides to start disrupting the ground rules or doesn't respect the ground rules, in some ways it doesn't matter how much law all of a sudden a lot of things are really up in the air.
Yeah, and I think it was one of the reasons I was really ambivalent about, impeachment, about consequences for people in the Trump administration that completely broke the law. I know Biden has been very, very emphatic about, we're not going to look back, we're going to look forward, we're going to move on, which is what Obama said about the torture regime,
right,
after the George W. Bush era. And one of the reasons I'm disinclined to just walk away is what you just said. If there are no consequences, if there's this tendency to sort of take the Etch-a-Sketch and shake it over your,
right.
I hate myself for your students, but, to sort of say, okay, we'll move on, we're going to draw a line and move forward, not having any kind of abiding, hard and fast legal consequences for lawbreakers really does invite the next person and the next person who says, make me, to feel emboldened. And I think it was a lesson I did cover sort of the torture era under Bush, and I really was very aware of the ways in which Obama, making the decision to prioritize the economy and to prioritize passing the Affordable Care Act, just let all of those loose ends lie, including
Right.
Guantanamo still being open. And
yes,
I think some of the fallout from that is what we saw in the Trump era, where it was really manifestly clear that if these are just norms and powerful people choose not to abide by them and there's no consequences, we're just waiting for it to happen next time.
Right. Okay, one more question before we take some audience questions. One of the really powerful parts of your writing in recent years has been your willingness to tell your own story. And in particular when it comes to talking about the pervasive problem of sexual harassment in the legal profession. Can you tell us a bit about, how you decided to allow yourself to be part of that story, and why you felt that was important?
Well, I want to start with a sort of precatory warning that I was a real coward, that it took me, close to 20 years to be brave enough to come forward and tell a story that I, had known to be true from when I clerked on the Ninth Circuit. And for folks who are watching, I was part of a group of women who eventually came forward and wrote about Alex Kaczynski, who was an incredibly charismatic, brilliant, very, very powerful kingmaker, really, on the Ninth Circuit, who would send all his clerks onto the Supreme Court. And I want to be super clear that it took me a very, very long time. And that, in fact, I came forward only after two women who were younger than I came forward in print, using their names, and described what he had done to them. And at that point, I felt as though if I had come forward in 1997, this would not have happened to them. And so there was an immense amount of feeling guilty and responsible for having been quiet for a long time. And I think I would also add that I was in a weird three-hat wearing position where I had clerked on that court. I was incredibly loyal. My judge was the chief of that court. I knew these people, I knew the judges, I knew how frantically they were worried about their own legitimacy for all the reasons we talked about in the Federalist Papers, neither purse nor sword. And I also was a reporter who had sources coming to me and talking to me. And then I also, in some ways, was a victim who had seen things. And so I just was so confounded by the lack of clear lanes in that story.
Yeah.
It was really hard. And, you know, one thing I did want to say about this, you and I talked about this last week a little bit. When I finally wrote about Judge Kaczynski, and I should note, before I wrote about him, when two other women had come forward, he sort of belittled one of them in the press. I didn't know them then. Belittled one of them and tried to shame her. And that was really, I think, what led me to write what I wrote. But the piece I wrote was really intended to be a piece about bystanders and why we keep secrets and why so many of these abusive relationships, particularly in the federal judiciary with, you know, lifetime appointed judges, Article 3 judges who can't be removed unless they're impeached, why we all keep the secrets and why they're always open secrets. And I was trying to write a piece about all of the power imbalances that led me to not come forward and all the advantages I got from not coming forward. It got kind of tricked out on Twitter as Dahlia Lithwick, Me Too's Judge Kaczynski, and which certainly I'm happy to have been, you know, a part of getting the record straight. But I really am sad that what got lost in the sort of haze of war around that reporting was this piece of it, which is in all of these open secret cases, hundreds of people know and nobody tells.
Yeah.
And that was the part that I felt I wanted to sort of offer up, both the mea culpa of, you know, I didn't help those women. I felt terribly responsible for what happened to them, but also how law, particularly more than almost any other field, is so hierarchical.
Yes.
And these judicial clerkships are the golden ticket, right? They're the way. In that sense, I think it's slightly different in the States too. You know, they are absolutely the launch pad to the best jobs and the best, you know, inside DC, you know, $500,000 signing bonus craziness that people will do anything and witness anything not to imperil it. And that was the part that I was most distraught about. And I guess I would just say I've covered a bunch of Me Too stories since then, including stuff that was happening at Yale Law School and other places. And what kills me is the secrecy. What kills me is the number of people who call afterwards and say, thank you for writing that story. It means I don't have to come forward. Here's all the stuff that I know. And that's the mindset that I'm trying to pierce.
Right. And that there's something about the legal profession that keeps that going. And that's really structured, it seems, to place a lot of barriers in the way of people having these conversations. Yeah. Okay, well, I want to open things up now. There are several student questions, Dahlia, that I'd like to put to you. One's about, you know, maybe the benefits and drawbacks of covering the court as a lawyer. You know, do you think that there's, I mean, clearly, I think there are real benefits to lawyers covering the court. Certainly in Canada, we see some journalists who also have a law degree who are covering the courts, but others who don't have a legal background. Can you talk to us a little bit about what you think that brings to the table, having a legal background? Does it make it more challenging, I guess, on the flip side, to be able to, you know, boil the court's decisions down and talk about or communicate them to the public?
I mean, I will say, judges, when I talk to judges, all judges, their number one complaint about the press is that we didn't go to law school. And it really affronts them that, you know, the person who's covering their courtroom, particularly in criminal trials, I hear this all the time, like literally doesn't understand criminal procedure and doesn't understand, you know, what a grand jury does and what the presumption, you know, of innocence means. And that, I think, makes them very upset. And that's understandable. I think that as I've covered the court, I've always been in a small minority of people who went to law school. The vast majority of the court's permanent press corps did not go to law school.
Okay.
Yale now has a 1-year program for reporters that's kind of like a little mini JD, where they can learn enough substantive law to cover the court really adeptly. And some of the best folks on the beat, including Linda Greenhouse and Joan Biskupic, have gone through that program. I think it makes a difference. But I think the last thing you said is the most important thing, which is law school. And I hope it's changed since I graduated, but it teaches you to be the worst kind of writer in a lot of ways. And when I first started writing for Slate, quite literally, our editor-in-chief was Michael Kinsley, who, you know, was a famous American magazine editor who came from the New Republic. I literally got back my first piece, and there was like strike throughs, like there was like 4 words in a sequence, and beyond that, it was I mean, it really had to unlearn how to write like a lawyer. And what I tell, and I will just tack on the free advice portion of the show, but
Please do.
What I tell law students is that you really have to kind of clear away the thicket and the swamp of all the throat clearing and all the on the one hand and on the other hand. And, you know, I don't want to take, like, you have to unlearn some of the stuff that you learn. And by the way, like, I think a lot of that stuff doesn't even make you a great legal writer. I just think there's like a culture of sort of jargony, turgid legal writing that we're trying to get away from in the law too, and in the academy too. But I think that really the hardest thing for me was to stop with the 4-paragraph introduction of all the throat clearing and all the caveating. And so I think, you know, without a doubt, it's better to have a law degree, because I think it's the water you swim in, and it's a tough learning. You know, Bob Barnes, who covers the court now for the Washington Post, who didn't have a JD, I think once told me it's a 3-year learning curve to teach yourself enough law to cover the Supreme Court. So it helps to know it, but then I think you almost have to like Control Alt Delete your entire writing style in order to communicate it effectively.
Right. Well, I mean, it like, the truth is probably lawyers and law students could learn quite a bit from journalists about clear writing, right? And I think you're right that in some ways we're all in this process of unlearning and getting away from that really jargony style of writing that actually is not clear to anyone, right? So there's an interesting development happening in the US right now, and that involves President Biden launching a commission on Supreme Court reform. And so one of the questions, maybe you can just, can you just talk to us a little bit about this commission? I think it's at a very early stage, right? So not a lot is known about what form the commission is going to take, what precisely their mandate will be, but term limits are on the table, which is certainly a big deal, I think, for the US. But, you know, more broadly, the idea of a president striking a commission to look at Supreme Court reform, this is a pretty major development. So any thoughts you might have on that?
Yeah, I mean, it's again, it's a uniquely American problem, because in some sense, the entire country now is enthralled to this court that, you know, if you really want to unpack it, you know, every Republican save one, or every conservative save one on the current court was appointed by a president who lost the majority vote. So you have a minority majority president, right, who's picking seats on the court, and then they're being confirmed by a minority majority Senate that is so malapportioned that the 50 Republican senators represent huge fraction less of the population than the Democrats. So I think that there is this sense, and, you know, we don't have to sort of talk about the founding and why minority majority institutions are such a big part of sort of the way the American government works. It's enough to say that I think there was a sense between refusing to confirm Merrick Garland for 10 months when Justice Scalia's seat was open, and then sort of the controversies around the Kavanaugh appointment, and then Amy Coney Barrett getting kind of sliding in under the tag, you know, just days before the election. I think that there was a sense on the part of Democrats that the court had simply been stolen, and that we are looking at a 6-3 court that, as I said, is not simply has been appointed by minority majority presidents and confirmed by minority majority senators, but that actually reflects a really extreme view of conservative politics, and that 6-3, there was an amazing piece, Adam Liptak did a piece on Monday about even just the religious liberty questions that are now coming to the court,
Right.
and
Yes.
the ways in which they are prevailing time and time and time again. There's no historical analog for that. And
Right.
so, right or wrong, progressives who have pretty much been on screen save for the last 50 years in terms of the court, who have not voted on it, have not organized around it, who I think sort of believed that we still were living in a Warren Court era of, big, huge progressive wins, got a really rude awakening in 2016 when the exit polls showed that by a 2-to-1 margin, people who cared most about the court pulled the lever for Trump. And that the
Right.
court was a voting issue for conservatives and not for liberals. And then Trump went ahead and not only did he seat 3 justices in a 4-year term, but has flipped 3 circuit courts, has seated more lifetime appointed judges on the district courts and the federal circuit courts than any president in modern history. So this was a juggernaut.
Yeah.
And it seems that Democrats really were pushing Biden in October. Particularly when Ruth Bader Ginsburg was sort of hastily replaced by Amy Coney Barrett, to really center that as an issue. And Biden, I think it's hard to overstate, particularly he's in this kind of New Deal mode where he's doing extraordinary things by fiat, but it's hard to overstate how small c conservative he is about the institution of the court.
Yeah.
So what he promised in October was that he would look at it, which is, sort of electoral code for go away.
Right.
And I think the commission is looking at it. The folks who are on it that we know of are people like Bob Bauer, Christina Rodriguez from Yale, who's an amazing young scholar. Caroline Frederickson is on it. Jack Goldsmith. They're really good people. Is any one of them a bomb thrower who's going to ask for court expansion? I don't think so.
Right.
And so then I think you're right. We're left with questions about term limits and, about jurisdiction stripping, which is incredibly problematic. There is definitely talk in academic circles of copying Canada's notwithstanding clause, right? Like ways to rein in this court that is uncheckable otherwise. I think that the mandate for the commission was to get this done in 6 months. So I think we're maybe meant to know something by the summer. But I think on this larger question, the sort of simple answer is court packing is the thing that almost killed FDR. And he was, to that point, the most popular president, right? So Americans, for all the reasons we led with, the court is really sacred. And 9 justices, even though it's nowhere to be found in the Constitution, is really magic. And the idea of messing with that is really anathema to people who think that the court is first and foremost a holy temple. And so I think what Biden was doing with the commission and kicking this down the road and sort of floating ideas, but not really, is trying to start seeding the idea in the popular imagination.
Okay.
But I don't know that we're going to see radical court reform.
Okay. Yeah, it's interesting. I mean, I've sometimes heard it said, you sometimes see Democrats talking about democratic strategy around the court and how it is so different than the Republican strategy around the courts, that, you'll often see Democrats say when the Republicans get a nomination, they nominate like the most conservative person that they can identify. They really put their values, they nominate someone who really reflects their values. Whereas Democrats, when they get their opportunity, they often appoint moderates. And so you sometimes, you often see that said, and I imagine then this, what you're seeing is in ways perhaps a sort of moderate response to, on the part of Biden, to calls to address what are potentially, I think, as you've identified, some very significant implications in terms of, you know, the composition of the court, given the types of political issues, legal questions that have political implications that are coming before the court. And then as well are now being brought, I think, proactively by groups who support further restrictions on abortion, for example. I mean, they see an opening.
And it's maybe worth saying, I would just say it quickly, John Paul Stevens, who was sort of seen as the lion of the court's liberal wing until he stepped down, he used to say, when he was asked, and I asked him this question in a public interview, how did you move from the sort of center right of the court when you came on to the far left of the court? And his answer was always, I moved nowhere at all. The court torqued around me. And I think descriptively this is right, that with very few exceptions, for the last few decades, every single person who has left the court has been replaced by someone either to their right or extremely to their right. And what was the center of the Warren court became the rabid left of the Rehnquist court. And what was the far right of the Warren court became kind of the center. And so I think the whole court has absolutely shifted. And again, I think, you know, this is not my opinion. There's an amazing study, Posner and Landis, that says that 11 of the top most conservative jurists to be seated at the court since the New Deal. Of those 11, 5 are on the current court. So this is just a really, really, really conservative court, which goes to your initial point that this has been a juggernaut. This has been the sort of absolute lodestar of the conservative legal movement in the United States. And there's nothing comparable on the left.
Right. Political strategy around the court.
Yep.
Great. Well, listen, I think we will wrap up. Thank you so much. You are so highly sought after as a speaker that we feel really privileged that you were able to come speak to us today. I'll let Dean Dodick just say a thank you as well.
Can I, before you do, first of all, I just want to thank you all, but I also want to say, whenever I talk to students, I say that there's always somebody who has a great question that they're too shy to put in the chat. So if you want to ferry it to Vanessa or to the dean, I will happily answer any question you were too freaked out to put in the chat, but thank you so much.
Thank you. That's very generous. Adam.
Well, thank you so much, Dahlia, and thank you so much, Vanessa. This was a pure joy. I think, you know, certainly for me, for many of the participants, I had people messaging. I saw remarks on Twitter. Just the range of subjects that you covered, from the U.S. Supreme Court to your own experiences, to the mini masterclass on legal writing that you gave us. It was just a really, really wonderful webinar. Thank you so much. And we really look forward to hosting you in person here back in Ottawa as soon as we are able to. So wishing you and your family all the best, stay safe, and thank you to everyone for participating today.